Welcome back to the channel, where we dive deep into real courtroom drama and break down the legal moves you might miss. Today's case is State versus Jonathan Deoyos, and trust me, this one's a roller coaster. At just 23 years old, Jonathan is facing a third-degree felony charge, evading arrest in a vehicle. That's serious business, punishable by up to 10 years behind bars and a $10,000 fine. But here's the twist. Jonathan isn't just fighting for his freedom. He's trying to convince the judge that he deserves a second chance. Will the plea bargain save him? Will the judge go easy or come down hard? Watch closely, because this isn't just about one bad decision on the road. It's about responsibility, accountability, and whether the justice system sees Jonathan as a reckless young man or someone who can turn his life around. And stick around, because later, the judge drops some powerful words that cut right through Jonathan's excuses. You're not going to want to miss that moment, so what do you think? Should a 23-year-old who admits to making bad decisions get probation or prison time? Drop your thoughts in the comments below while we roll the tape.
This is an application. Where's your client?
He's coming up.
Nobody wants to approach with their attorneys anymore. What's going on?
I guess he wants me to take the deal and be on probation for 6 years.
That could be it. That's it. Way to go. All right, court is calling 2025 CR 003498 State versus Jonathan Deoyos. Could I have parties announced?
Jason Gearhead for the state, Your Honor.
Sean Brown from Mr. Deoyos, Your Honor.
And are you Mr. Deoyos? Counsel, have you received all discovery? Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Deoyos, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you?
All right, pause here. Did you catch that? The judge just reminded Jonathan that even though there's a plea bargain on the table, the court isn't bound by it. This is huge. Many people think a plea deal is a guarantee, but judges can absolutely reject it if they feel it doesn't fit the crime. Imagine thinking you're walking away with probation, only to hear the judge sentence you to prison on the spot. That's the kind of high-stakes tension we're dealing with. Here, what do you think? Should judges have that much discretion, or should plea deals be ironclad?
Proceeding on the indictment as presented.
I believe we are, Judge. Okay, thank you.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with evading arrest, detention in a vehicle as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is, Your Honor.
Mr. Deoyos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at a $2,000 fine. State recommends deferred adjudication. This is to be run concurrently with the case from Guadalupe County, and it's case number 2.
So here's the deal. Jonathan's plea bargain calls for a $2,000 fine, deferred adjudication, and probation running alongside a separate case from another county. But look closely. The state just slipped in some heavy conditions: 6 years of supervision, 200 hours of community service, mandatory treatment evaluations. This is more than a slap on the wrist. It's essentially saying, we'll let you walk, but only if you walk the straightest, narrowest line possible. Would you take this deal, or would you risk rolling the dice with a jury?
231390 CRC. Did you understand that to be the plea?
Yes, ma'am.
Defense?
That is our agreement. Yes, ma'am.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Excuse me, Your Honor?
Have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 6 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations? You need to speak up.
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. State Exhibit number 1 with office attachments.
Judge, I've reviewed that with my client. We have no objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We'd ask to waive the PSI, Your Honor.
All right, anything you wish to say on behalf of your client?
Judge, he accepts responsibility. Obviously, we're here today. He's working. He lives with his family. He's got a good support system. Understands he made a terrible mistake and choice, and we're asking him to follow the agreement that we have with the state.
All right, how old are you?
23.
All right, why are you doing this?
It was a bad decision.
Why are you making bad decisions that could perhaps result in your death and other people's death?
Hanging out with bad people.
Now, if I talk to the person who was the passenger in the vehicle, if he were before me charged with this offense, which he can't be because he wasn't driving, but if he were charged with this offense, you know what he'd say? I was hanging around with bad people, and I'd say, well, who are these bad people? And you know what he would say? You are. And in the big scheme of things, you're the one who was driving. Did he have a gun on you making you drive? So you're the bad person, right? You still have a chance to change your ways. How did you get to?
Wow! Did you hear that? The judge just flipped the script on Jonathan. He tried blaming bad people for influencing him, but the judge wasn't having it. You're the bad person, she tells him, reminding him he was the one behind the wheel. That's a gut punch. This moment shows exactly how judges cut through excuses in court. Do you agree with the judge here? Should Jonathan take full ownership, or do friends and environment play a role in decisions like this?
Court today.
Truck.
I'm sorry?
My truck.
All right. So what I can tell you right now, today is the last day you're going to be driving that truck. You know why? Because as a condition of your probation, I'm not going to allow you to drive until you complete the defensive driving course. Do you understand?
Yes, sir.
And after all of this happened, you live with your parents?
Yes.
They didn't take the keys to your vehicle and say you're not allowed to drive because you're not responsible? So I'm going to do it. All right. Are you employed?
Yes.
What do you do?
Auto detailing.
All right. You're going to have to take the Via bus or get an Uber because you're not allowed to drive. Do you understand? Use words. Okay.
And Judge, that's until he takes the definitive driving class and provides certificate to probation.
Yes.
Okay, thank you.
And there's going to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. And when you're drug tested today, what are the results going to be?
Positive
For what?
for no drugs.
I'm sorry, what?
For no drugs.
Just alcohol, he said.
Oh, just alcohol?
I don't do any.
Well, I mean, what are you going to be positive for? Speak
Mayor,
now, forever hold your
we're-
peace, because you will be tested today. So what is it going to be? If you use earlier this morning, if you use before I'm placing you on probation, that's not a violation of your probation. If you use after, it's a violation. So what are you going to be positive for? Your attorney wasn't with you using drugs. You were with whomever you were with. He doesn't know. So what are you going to be positive for?
I mean, not down, drink or smoke or anything like that.
So you're saying when I send you to go do a UA, you're going to not be positive for any drugs. You need to use words.
No.
So you're going to be negative. All right. I'm going to want a UA today. And if the UA is positive, what's going to end up happening is you're going to go into custody and going to do a TAP evaluation in custody. You understand? All right. So there's to be a UA today. If he's positive, then you'll report back. Well, you're going to have to report back to court anyway. So if you're going to be positive from the testing, you need to make sure that your parents or somebody can pick up your truck for you. You understand? So there's a UA today. No later than 1 p.m. There's to be the defensive driving course. $100 hours of community service restitution if you obtain some sort of trade school.
And here's another dramatic turn. The judge is making it crystal clear. Jonathan will be drug tested today. If he tests positive, he's going straight into custody. No second chances. Think about that. He's standing in court, being asked point blank if he used anything. This is a pressure cooker moment. Will he gamble on honesty or risk getting caught in a lie? It's not just about today. It's about trust. Once a judge feels you can't be trusted, every future decision gets harder. What would you do in his shoes? Confess or deny?
Certificate or higher level of education, the community service hours will be deemed satisfied. There's to be no contact with I saw his name.
Gilbert Latta, your
Nice.
honor.
Thank you. There's to be no contact. Thank you.
Yes.
With Gilbert Lara. Field visits one time per month for 6 months. And it is to be a $2,000 fine. That will be probated, concurrent with case out of Guadalupe County, number 231390CR. They're asking for 6 years deferred adjudication. You want to speak to that?
Yeah, Judge, I would ask that he get the 4. I think 4 would be sufficient under the circumstances of this charge.
All right, 4 years deferred adjudication.
Thank you, Your Honor.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, just one moment. There's to be a TAP evaluation out of custody if the defendant tests negative. If positive, then the TAP evaluation will be in custody. And there's to be no driving after June 10th, 2025 at 5 p.m. All right, I'm sorry.
And there you have it. Jonathan avoids prison. For now. Instead, he walks away with 4 years of deferred adjudication, a $2,000 fine, strict probation, and some very stern words from the bench. The judge didn't just give him a sentence. She gave him a wake-up call. But here's the bigger takeaway. The justice system doesn't just punish, it tests. Jonathan now has years to prove he can change, or risk losing everything. Will he succeed? That's the question. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Because trust me, you do not want to miss the next one.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You can't be racing through the city like it's Fast and Furious, because even that, when they have controlled movement, people still are injured, and you're not a professional. You could have killed anybody. Your passenger could have been killed. And if your passenger would have been killed, you know what? The state would have been looking to file charges. You understand?
Yes, ma'am.
Or I should say, receiving charges from the police. And this would have been more than just an evading arrest and detention in a vehicle. All right, good luck to you.
Thank you, Judge. May I be excused?
Yes.
Thank you.